Yes.
Petitioner is destined from.
Please use the microphone.
Petitioner is destined. Hello. Petitioner is destined from attending his classes, matter.
What do you want?
For upgradation, madam.
Give the number. Yes.
Upgradation, ma'am.
Give.
Kindly consider, my lord, upgradation, my lord. Upgrading.
Individual.
The way you all are upgrading, it seems the entire list will be toppled. I do not know how it can be taken up. Just see, the whole list will go upside down if this is done. If you all do not maintain proper urgency and then mention, then I do not know. Yes.
কবে বলবেন?
110 matters. Don't mention it today. Just wait for tomorrow.
Permit to mention, my lord. I am seeking leave in a matter, my lord. This is regarding SLST 2016, my lord. 2016, my SLST, my lord. And in a Rajiv Brahma matter, Honorable Division Bench passed an order to further counseling, my lord. 5th round of pursuing counseling is ongoing, my lord. Respondent authority published
16 SLST.
2016 SLST, my lord.
2016.
First SLST, my lord.
Yes.
As for assistant teacher, my lord. And
Primary.
yes, my lord, upper primary, my lord.
Yes. What has happened?
And my lord, the petitioner is a a candidate where he get the intimation letter to participate in the selection process, my lord. And the respondent of the arbitrary, my lord, they did not call the petitioner. Even the less meritorious candidate was called for the participation, my lord. And 21st is the date, my lord, for commencement, my lord. Tomorrow, that is, my lord.
So what were you doing for so long?
My lord, I make a RTA application. I didn't get any reply from the department, my lord.
Yes.
Also, 3 representation I made to the department, but I didn't get any reply from there, my lord. And tomorrow also he make a representation to the respondent authority. And my lord,
21st is tomorrow.
is
Right.
kindly, my lord, if the matter is take in the first of the list, my lord, maybe we.
Maybe what?
If my lord, if we communicate with the order and if something is.
You cannot expect magic to happen.
No,
You
my,
have
I'm
to
not
give
saying that.
time.
I'm not saying that, my lord.
Then tomorrow
I'm
is
trying on
21st and
our
you
best.
to come. No, you file it. I'll see what is to be done. Nothing can be done now.
My lord, regarding item number 1661, the urgency is this, my lord, the petitioner.
Mentioning.
My lord, I have already given him.
Then don't mention. Lordship.
What has happened, my lord? The teachers of a certain secondary education school, my lord, they are the main accused person. Now, my lord, children, my lord, they have been, my lord, assaulted. My lord, they are the teachers who are doing the ragging, my lord. My lord, this petitioner has recovered his son, rescued his son. My lord, the principal and 2 teachers of a certain secondary education school, my lord, they are abusing all the children. And my lord, there no disciplinary proceeding till date has been taken. Nothing has been. They are not been suspended.
Who are you?
My lord, what has happened, my lord? A criminal.
Who are you?
I am the father. I'm the father of my 14 years old son who has been recovered after a rescue call. My son called me. I went over there. There was cigarette burn marks, injuries over his body. My lord, Sharoda Mandir Shiksha Mandir. My lord, this is in Moshagram. Secondary education school maintaining hostel. Now all the students are facing the same thing. They are scared. Now the principal and the teacher is maintaining the same position. Till date, I made several representation. Criminal case has been registered, my lord, after request. 14 days. Already CCTV evidence has been tampered. They are saying that we maintain CCTV footage for 7 days. 14 days, 20 days later, the FIR has been registered. Criminal proceeding is there, my lord. But if they are not suspended, all the students of that particular school is at risk, my lord.
And if the teachers are suspended, how will the school continue?
My lord, my evidence will be at least, my lord, saved. Already the CCTV.
And the school will remain closed.
No, not the school, my lord. The particular teachers, they are doing it, my lord. They has to be
The
suspended.
teachers have to be suspended.
Or
How
at
will
least,
the
my lord,
school run?
my lord.
How will the school run without the teachers?
But my lord, there are teachers who are, my lord, they're getting drunk, making the students stand outside in the night, my lord, till 1 a.m. They're teachers. They are giving cigarette burn mark injuries, my lord. They're abusing, giving slangs, my lord. This is the allegation. Now, my lord, this father has also been called and threatened to withdraw the case in the school.
What do you do?
My lord, I do service, my lord.
Where do you serve?
My lord, normal job, my lord. Simple job. My son is 14 years old. Seeing the reputation of the school, I admitted him. I got a rescue call. I went over there. My boy was not speaking for 2 days, my lord. Already CCTV footage has been compromised, my lord. Some disciplinary proceeding. For that I have come, and not only my son's life, my lord. Several other students are there.
Leave. Thursday it will appear.
Great.
Serve notice.
Yes, my lord. I'll serve. I'll serve. Grateful.
My candidature of assistant teacher has been arbitrarily rejected by the
Yes, please.
I'm taking leave to file on matter. The matter pertains to grave irregularity in the NEET UG 2026 examination. Your Lordship, my case is that the urgency in this matter is that the NTA, the governing body which has conducted the examination, has given me 280 marks. Whereas upon analyzing the OMR sheet and the final answer key, I evaluated that my estimated marks will be above 650. Your Lordship, there is a difference of 370 marks.
280 and
Yes, Your
650.
Lordship. Yes, Your Lordship. It's a grave irregularity, Your Lordship. I will be unable to participate in the counselling process if my marks are not rectified. I have made several representations.
When is the counseling starting?
Your Lordship, the result was declared last month on the 17th. It will start soon.
All right. You file it in the department and give the number. It will appear in the list on Thursday.
Thursday, Your Lordship.
Lord.
Your Lordship.
My operation, doctor, my lord, concerned doctor, my lord, suggest me, I am not fit person travel, my lord, long travel, my lord.
Yes.
My lord. Only
What?
transfer, my lord.
Yes, so what? Why are you mentioning? Hand over the slip.
Your Lordship, I'm seeking simultaneous hearing for a matter. One matter is in the daily cause list in item number 88, and the similar matter has already been filed earlier. That is WPA number.
Let the daily costless matter be taken up, then mention.
Lordship,
Yes.
may be permitted to mention for upgradation, Lordship. There is a grave urgency. Lordship, I'm pursuing PG degree in SSKM Hospital. Pursuant to an order passed by division bench of this honorable court, my validity of my admission under the
Hand over the
in-service
slip.
quota was.
Hand over the slip.
Lordship, I have been served with another notice after a recent order has been passed.
All right. Yes.
May I be permitted to mention for correction, ma'am? Lordship,
Give.
Lordship, may,
Give.
Lordship, may I be permitted to mention item number
is not getting full salary.
Give.
item number 1724 from monthly list of July. Lordship, kindly fix a date so that I can serve the copy of to the office of the GP, Lordship.
Serve it now.
Lordship,
Serve it now. Yes.
But one pension matter, my lord, the petitioner is not getting pension for the last.
Why are you mentioning?
Upgradation or inclusion? Inclusion Budhbar.
Inclusion is, there is a date fixed for inclusion.
These matters, my lord, the kindly.
110 matters. Come tomorrow. Let my officer go through these bundles of
I have not.
upgradation. Do not give.
I'm sorry to disturb your lordship. This is regarding the school matter which was taken up last Friday, Gyan Bharati school. I indicated to your lordship, I had mentioned the matter previously. It is item number 96. It's regarding an attempted appointment of a DDO. Now, a letter has been freshly issued, indicating that the DDO is being requested to take over charge immediately and the school is to assist. I was only beseeching your lordship if any accommodation can be made anytime during this week, item number 96 of the days list. Anytime, I am covered by one of your lordship's order,
Wednesday it will appear. Wednesday, Budhvar.
1625 was grave urgencies this matter on 20.
Hand over the slip, please.
I have handed over, but before 25th, kindly take, because matter on 25th, the disciplinary authority is going to terminate me. Bias disciplinary authority.
Let us see.
Item number 1895. Tomorrow, my lord has fixed one of the matter of this petitioner. She is the teacher in charge of Dokkineshwar High School, 60% handicapped. Now, my lord, if your lordship tag this matter, because these are
Let tomorrow's matter be taken up, then I'll tag.
this matter is starting the disciplinary proceeding, which I have challenged. So, my lord, tomorrow's matter is for removal of my.
Let tomorrow's matter be called, then you mention.
Well,
Yes.
this matter can be tagged together.
Not right now. Yes.
No matter, my lord. Item number 1222 of
Why are you mentioning?
upgradation.
Give the slip.
My lord, mentioning for upgradation.
We will go through the lack if possible, my lord, to accommodate with my lord. Kindly allow me, my lord. Otherwise, my lord, petitioner will deprive, my lord.
What matter? Which
For,
matter?
for my lord, this I seeking for leave in matter, my lord. I mentioned
Leave? For what?
for the my lord. I mentioned right now, my lord. This is regarding SLST, my lord, 2016 and
Counseling.
yes, my
See, you
my lord.
tomorrow is the last date of counseling, and today you've come. How can the court grant relief to you? Will you please say?
My lord, if possible, my lord, tomorrow is a if taken up, my lord, maybe kindly, my lord, allow.
It name into leave the din. Tomorrow it will appear ensure service. Let us see.
Grateful, my lord.
Call the list, please.
My lord, I am for the petition, your lordship. As per your lordship's last direction, an administrative notice was sent to them. Administrative letters was there.
Lord, on my prayer, my lord, since the my lord, it is a 27 years back petition, my lord. Nobody was communicating with me. My lord, after the issuance of the notice, my lord, my lord, two of the contempts, my lord, contempt number 2, 3, and 4, my lord, they, my lord, came to me, my lord. But now the question is, my lord.
Contempt number 2 has expired. It is
No,
mentioned.
3 and 4. Sorry, 3 and 4.
My lord, there are two contempt applications, and I have also claimed for my damages. What the damage they have
has
created?
to be, my lord, decided after the, my lord, let the contempt application, my lord, let me be conversant with the, my lord, all the facts, my lord, whether the opposition was filed or not. I'll have to check up.
Nothing, no affidavit has filed.
That has to be checked up. My lord, advocate record is not found. That is the real trouble. We are always here to assist your lordship, my lord. But kindly grant me sometimes, my lord, so that, my lord, new advocate
Then your
record
lordship,
be appointed, my lord,
may
so
I
that
pray to your lordship that your lordship kindly pass an order of warrant to present the contemner to the court.
Which contemner?
All the contemners.
Your ladyship, I beg to appear on behalf of
Why?
respondent number
Look,
6.
The matter is pending for so long. You are not taking any steps.
No, I have taken steps. Every
My
time.
After
My lord,
27.
rule has issued already. No compliance on their part. Neither any affidavit. Nothing, my lord.
What is to be complied?
Affidavit is to be
complied.
My lord, the rules should have been answered by the
What
affidavit.
is to be complied? Please say.
My lord, the injunction order, they are still violating the injunction order.
What happened to the suit?
Suit for injunction, my lord.
Yes, what happened to the suit?
My lord, injunction has been granted,
Go
but
before the suit court, get it done.
your lordship, but the difficulty is neither in contempt nor in suit. They are not giving the name of the legal heirs.
And now you want a contempt rule to be issued against whom?
Rule is already there.
Lord, contempt rule was issued. Everybody appeared, my lord. Lord, I cannot recollect at this stage, my lord, whether the opposition was filed or not. After 27 years back, my lord, it is very difficult to, my lord, recollect. Lord, I will ask my clients, my lord, to engage one advocate on record. My lord, he is also found missing. Whether he is whether he is practicing or not, whether in during Corona period he died or not, nothing is known. So, my lord, it will take some time, my lord.
Your ladyship, in the meanwhile, I beg to appear on behalf of respondent number 6. We filed our wakalatnama, but since the matter is coming up after 27 years, there's been a change of counsels.
All right.
So if I could request the petitioner to serve a copy or
your lordship will serve.
If they can reserve the copies, your ladyship.
You have to check up the whole thing, my lord. Inspect the.
See, I have got a report in front of me which says that the contemptor number 1, the welfare association, does it still exist?
Yes.
No such person in the address. This is what the speed post report says. Nagendra Rai, no such person is in the address.
No, my lord.
Sadiq Ali,
expired, my lord.
he has expired.
We filed the report.
Sadiq Ali.
I'm representing Sadiq Ali.
If I may just intervene, your ladyship, respondent number 6, contemptor number 6.
What is his name?
Ajay Biani.
Ajay Biani. Yes, item was delivered.
Instruction is what I'm saying is that this street Satyam Shivam Sundaram Welfare Association does not exist anymore. It does exist.
It does exist.
Absolutely, the association does not exist. This is what the report says. Ajay Biyani has received it.
And present in court.
Sadiq Ali, are you
Yes,
representing?
3 and yes, my lord.
3 and 4,
I am
they have received. 5, Vinod Khemka, no such address. William,
Perhaps he expired.
expired. Yes, William,
Yes.
no such address. Ajay Biyani is there. And 8, Daniel Subba, no such person. Rajagiri, no such person. What is to be done? Who is going to comply the order? The
According to
association is
my
not there.
instruction, both the institution your lordship has read, they are existing till there at that address.
The report doesn't say so.
So 3 administrators were there originally.
All right, please come. The contemner number.
Lord, kindly then allow us to
One small indulgence, your ladyship.
4 and 6.
Yes, your ladyship, if your ladyship could direct the petitioner to serve a copy, at least your ladyship.
Your lordship will.
Matter is coming up
And
after.
may I pray to your lordship that for the substitute service, let us
3, 4, and 6.
notice by newspaper.
Submits that as the matter has appeared in the list after nearly 27 years, the parties are not ready with the papers. Stop. Prayer has been made to direct the petitioner to serve a copy of the application upon the said parties. Stop. Paragraph. Let copy of the contempt application be served upon the learned advocate representing the aforesaid contemners. Stop. Release the matter for further consideration on 14th of September 2026.
My lord, let Dr. Rai's legal heirs name should be there.
So that is
They have not been
concerned. That
they
is
have
so
not
much
given.
concerned, not in contempt.
My lord, in contempt also. He is also a contemner.
Person expert, I do not know how the
How can the heirs
right
be
to sue.
contemners?
Yes.
Try to understand.
My lord, they are violating the injunction order.
Suit court and get it done.
Yes.
Acha. On 14th of September. Stop. Nothing more.
Grateful, your ladyship.
Deeply blessed.
Deeply blessed, Lord. সেখানে বলা যাবে না contempt person হবে।
এক আর 2 একসাথেই হবে কি? জেনে নিন 1 আর 2 একসাথে আলাদা হয়েছিল, সেপারেট অর্ডার করে দিন। এটা কি 3?
And in spite of our lordship, my lord, they have not yet paid the dues, my lord. The lordship was pleased to direct them to pay the amount, my lord, but they have not yet paid, my lord.
Who is to pay?
The petitioner, my lord. Petitioner.
Sri Sham. Sri Sham.
This is Sham project. The last question, my lord, I am the respondent number 7. Whether the demand has been served, my lord, I have got it, my lord. It has already been served.
And Sri Sham is not appearing today?
No. A total dues of around 2 crores. One on the basis of unauthorized construction and
The thing is,
his dues.
if they are not paying, there is a procedure as to how you have to.
Kindly give me leave, my lord, to take the.
Certainly.
Certainly.
And why leave is required? Leave possibly will not be required.
Kindly observe, my lord, that leave is given to the corporation to.
And appears on behalf of Messrs. Sri Sham Projects Private Limited and another. Stop. Paragraph. Learned advocate representing the Kolkata Municipal Corporation relies upon a communication made by the executive engineer within bracket C/building/borough 4 signed on 11th May 2026 in support of the submission that request for payment of charges for demolition of the unauthorized construction and for unauthorized use of the building was made known, not was, has been made known to the aforesaid person. Stop. Payment has not yet been made. Stop. Paragraph. it will be open for the corporation to initiate proceeding in accordance with law for realizing the dues from the person responsible. Stop. What remains to be considered?
This matter was kept pending only for this period.
We shall take steps to realize there are 10 ballot.
The division bench ordered the matter to be
Release the matter for further consideration on 10th August 2026. Some more time.
Then 15th or 20th
August.
August.
17th of August.
Yes. Grateful to you.
17th August.
diplomat.
Grateful to you.
এই পাখাটাকে বন্ধ করতে বলুন তো, কাগজ উড়ে যাচ্ছে সব। এই পাখাটা বন্ধ করে দিন তো।
Your Lordship was as ad interim Vice Chancellor appointed by the Chancellor to carry out the duties and functions of the Vice Chancellor. So while she was discharging her duties, she retired from her services as a professor of Calcutta University. After that, Your Lordship, just before she was going to she had to release her office, but then, Your Lordship, there was a process for appointment of an adjunct professor. And the Department of Home Science Nutrition, they took up this issue and they referred her name for being appointed as an adjunct professor. Lordship, may I make it clear? The adjunct professor, Your Lordship, there are two ways of appointing. One, they are appointed on remuneration, in which, Your Lordship, the incumbent is supposed to apply for it. And the other one is as an honorary adjunct professor where there is no remuneration whatsoever. So that is a voluntary appointment made on the reference made by the department. So when her name was proposed, she came to know, and she was, at that time, she was discharging her duties as a Vice Chancellor. She told she delegated the matter to the registrar to take all steps that are required to be taken.
And somebody is required to propose.
Lordship. So the proposal came from the department, the dean of the department. I'll place it before Your Lordship. I just tell Lordship in a nutshell. So the proposal came from the dean of the department. It was placed before the syndicate. And when it was placed before the syndicate, she recused herself from the entire issue and she handed the matter to the registrar she delegated her powers to the registrar. After that, Your Lordship, the syndicate took a resolution. On the 3rd of December, a resolution was taken by the syndicate. And that resolution was also communicated to her, that you have been appointed as an adjunct honorary professor at the department. But at that time, she was still holding the office of a Vice Chancellor, so she could not take over the charges. Thereafter, Your Lordship, when she was released from her office, she took up the charge of the adjunct honorary professor in the university.
And there is no upper age limit for this?
No, Lordship, 70. 70. Actually, Lordship, there is no upper limit. But so, Your Lordship, what happened is, while she was discharging her services, I would say not duties, her services as an adjunct professor, she received a letter saying that your appointment has been irregular. Because, Lordship, what happens in the university, every decision which is taken by the syndicate has to be ratified at the next syndicate. So on the 3rd of December, when the resolution was taken, the next date when the matter came up and the petitioner before yourself was a Vice Chancellor, she saw the resolution, she said, let the matter go out. That was noted. So, Your Lordship,
what does this mean? Let it go out?
Lordship, once a resolution has already been taken, it's full and final, and the Vice Chancellor, Your Lordship, in her own capacity, she could not handle that matter. So she simply said, let the matter go out.
And it was not required to be ratified in the
No,
next...
Your Lordship,
that
no.
Is what
because
you said.
because the final resolution had been taken. Lordship, what is required to be ratified is a decision. There's a difference, Your Lordship, between a decision and a resolution. So a decision, this was not a decision. It was a complete resolution taken and the resolution was communicated to her by the registrar.
This can be done.
This can be done.
All right.
So in my humble submission. So, Your Lordship, what happened is she was discharging her duties as an honorary adjunct professor. She receives this letter saying that you cannot. So she applied, came before this honorable court saying that allow me to discharge my duties. I'm not asking for any remuneration. I'm not doing anything. She is just a person who loves teaching. She's an educator by heart and she wants to teach. So this is in a nutshell her case. And the case of the university is that the matter going out of the list means that the decision has been nullified. That is what your lordship has to decide. I'll place the documents before your lordship. Your lordship has to decide whether a resolution which has already been taken and become final and has been acted upon.
Has been acted upon.
Has been acted upon because she's already joined. So has been acted upon. Whether that resolution is actually a decision which requires to be ratified. First, secondly, your lordship, once does the noting matter to go out would actually mean that that issue has been nullified, deemed to be null and void. That is your lordship. May I place the documents for your lordship? Lordship will kindly come. Lordship will kindly come to the writ petition. Annexure P4 at page 46. This is 29/10/2024. This is a short resolution.
What does this short and long mean?
Lordship, sometimes this is what my client has expressed to me. Sometimes, your lordship, certain issues are brought before the syndicate, which have to be immediately acted upon. So a short resolution is taken, which becomes final. And sometimes, your lordship, the long-term decision-making process is set into place. The proposal is given. They decide, yes, we will decide on it. And on the next date, it is ratified. So a short resolution, lordship, there are no rules. I cannot cite any rules or any statutory regulations of Calcutta University to satisfy your lordship on this. But this is the understanding which was given to me by my client, that a short resolution is a resolution which is normally taken on urgent expedient matters. So this is a short resolution which was taken on the 29/10 of 2024. Now, items placed on the table. To consider a proposal received from the Dean Faculty Council of PG Studies in Home Science regarding appointment of adjunct faculty in Food and Nutrition course at the Department of Home Science. Resolved, your lordship will kindly see, resolved that the proposal of the Dean Faculty regarding appointment of Professor Shanta Datta Dey as honorary adjunct faculty in Food and Nutrition course in the Department of Home Science, Calcutta University, be accepted and approved. So, lordship, that resolution was accepted, it was approved. The registrar be entrusted to communicate necessary information to Professor Shanta Datta Dey at an early date. The Honorable Vice Chancellor did not, this is very important, your lordship will kindly see, the Honorable Vice Chancellor did not take part on the deliberation of the above named item, and therefore the Dean Faculty Council of PG Studies in Home Science chaired during the deliberation of the above item. Your lordship will come to the next page. Here is the communication, your lordship. On the 3rd of December, 2024, it is communicated to Professor Shanta Datta Dey, Department of Home Science, University of Calcutta, dated 3rd December 2024.
One thing, page 46, this resolution is dated 29th of October.
Yes.
And this is signed by the registrar on the 3rd of December.
Yes, because the resolution was confirmed on the 3rd of December. Lordship will kindly come to the next page.
Yes.
Lordship, this resolution was taken on the 29th of 10/2024. It was approved on the 3rd of December. And thereafter, your lordship will kindly come to page 47. This is the communication.
Yes, this is also 3rd of December.
This is on the 3rd of December.
Yes.
It is coming. I am directed to inform you that the syndicate at its meeting on 29/10/24, while item number 81 has resolved the following. To consider a proposal received from the Dean Faculty of PG Studies in Home Science, Calcutta University, regarding appointment of adjunct faculty in Food and Nutrition course at the Department of Home Science, Calcutta University. Resolved that the proposal of the Dean Faculty Council for PG Studies in Home Science, Calcutta University, regarding appointment of Professor Shanta Datta Dey as honorary adjunct faculty in Food and Nutrition course in the Department of Home Science be accepted and approved. The registrar be entrusted to communicate necessary information to Professor Shanta Datta Dey at an early date. This is for your information for taking necessary action. So this resolution is communicated to the writ petitioner, Your Lordship. Your Lordship will kindly come to the next page. Thereafter, Your Lordship, she was released from her office. That perhaps is not annexed before Your Lordship. When was she released? No. When was she? Then, Your Lordship, on the 31st, she was released from her office.
31st of?
In October 2024. She was 25. She was released from her office.
October 25.
25.
All right.
And thereafter, Your Lordship, she was... Lordship will kindly give me a second. I may be wrong with my date. Oh, Lordship, she was a VC till 29th of October 2025.
29th October?
October 2025.
All right.
And thereafter, Lordship, she took over charge. After receiving this letter, she took over charge on 31st of October 2025. And thereafter, she receives this notice. She receives this notice on the 28th of November. Lordship will kindly come to page 40.
No, page 48 you were showing me.
Lordship.
She joined.
Yes. Lordship, this is a letter that was given to her on the 31st of October, and she accepts it and she joins on that very same day, 31st October.
Where is the letter from the registrar?
Lordship, the letter from the registrar is page 47. 47 and then 48.
47 is 2024.
Lordship.
3rd of December 2024.
So she's communicated.
She's communicated
and
about
then
the
on
resolution.
page 48, Your Lordship will kindly...
She joins.
She joins. 31
After 10 months.
Yes.
After 10 months.
Because, Lordship, she was holding the office of the Vice Chancellor. So while holding the office of a Vice Chancellor, she could not have joined.
All right.
So she released the office on the 31st of October. She joined on the 31st of October.
All right.
So, Your Lordship, she joins with reference to the letter dated 3/12/24. Lordship will kindly see. I do hereby gladly accept the proposal for the appointment of honorary adjunct faculty in Food and Nutrition course in the Department of Home Science, duly accepted and approved by the syndicate at its meeting dated 29/10 so-and-so. And subsequently, I am joining in that post on and from 31/10/25 after my assignment as authorized Vice Chancellor has ended on account of appointment of a new Vice Chancellor. So she joins. There, Your Lordship will kindly come to page 49.
Yes.
This is dated 28th November 2025, received from the registrar. From this registrar, the letter is to Professor Shanta Datta Dey, ex-Vice Chancellor, authorized University of Calcutta. It's an email. Respected Madam, I would like to inform you the following facts. As per Office Records Meeting Section, Calcutta University, a short resolution on item number 81 of the syndicate dated 29/10/24 was made on 3/12/24. Item 81 to consider the...
Then the resolution
The
comes.
resolution has been set out, Lordship. I will not trouble Your Lordship. And then Your Lordship will see. Please note that the above resolution was circulated among all the members. Lordship, then Your Lordship will kindly come to page 52. Second paragraph, Your Lordship. They say the registrar subsequent resolutions of all the items of syndicate dated 29/10/24 was signed by the Honorable Vice Chancellor, Professor Shanta Datta, and the Registrar for Circulation on 3/12/24, where resolution number item 81 was stated as matter be taken out. Please note that the above resolution was circulated among all the syndicate members. All those facts were placed before the syndicate members during the syndicate meeting held on 27/11/2025. In connection with item number 2, it was considered therein that the matter be taken out denotes withdrawal of such item from the confirmation list. This is there standing. Since the resolution number 81, which circulated the matter be taken out, the resolution as noted in point 1, and resultantly, consequently, the appointment letter issued by the registrar stands inoperative. So this was the impugned thing.
And this is the challenge.
This is the challenge. Lordship, university was directed to file a short report placing on record all the resolutions that have been taken and how the resolutions have been taken. May I place before your Lordship the affidavit in opposition filed by the university. Lordship, R1 are the rules and regulations of the university. Lordship will kindly come to page 22.
Prior to going to the opposition, what would be your submission with regard to page 51, the portion which is impugned, matter be taken out?
Lordship, Lordship, my submission before your Lordship would be, Lordship, from the affidavit in opposition, that the resolution 81 was placed before the writ petitioner. She was then the Vice Chancellor. She could not have confirmed that resolution. And that resolution, your Lordship, was placed on the 4th of December. On the 3rd of December, it had already been confirmed and it had been circulated.
And there was no scope for any further
There was no scope for any
the,
further circulation by the VC, because, Lordship, I'll place before your Lordship from my affidavit in reply that the VC had delegated the matter to the registrar. Now the registrar was to take a final decision. When the matter was tabled before the syndicate, she reclused herself. Then a final resolution is taken on the 3rd of December. After that final decision is taken on the 4th of December, when the matter is placed before her, Lordship, we also, in the course of our working, we do it, your Lordship. We often, your Lordship, say, let the matter go out. It does not mean that your Lordship have deliberated on that merits of that matter. It is not to be before your Lordship say, let the matter go out. Also, Lordship, all other administrative functions, something is before a decision-making authority, it is not within their zone. They normally say, let it go out. I'm not going to decide on this. So, your Lordship, it is very inaccurate statement. Let the matter go out, because on the 4th of December, your Lordship, that was a resolution which had already been taken. It was final. So, to come before her was a mistake. It should not have been placed before her for confirmation. So, she simply said, let the matter go out, and it went out. After that, your Lordship, they took up the matter on the 29th of November 2025, 1 year later. And they suddenly took a decision. Since it is matter go out, the decision becomes void, inoperative.
All right.
So, your Lordship, I'll place before your Lordship the resolutions that were taken by the university. Before I place that, your Lordship, kindly come to my affidavit in reply. I'll place the power, that authority that was given to the Lordship, my affidavit in reply, page 20.
Yes.
Lordship, this is to the Registrar, University of Calcutta, forwarding the recommendation, the appeal for proposing the name of Professor Shanta Datta Dey as honorary adjunct faculty in food and nutrition course at the Department of Home Science. Lordship, this is dated 29/10/2024. Write down, Your Lordship, at the signature point, Your Lordship. And this has been given by the Dean, Professor and Acting Dean, Faculty of PG Studies in the Fine Arts and Music. So, Lordship, this is to request you to consider the appeal of the faculty from the Department of Home Science in this context. I like to mention that in spite of repeated requests to call the departmental committee meeting to discuss the above mentioned issue, head of the department has refused to call the same. As you know, home science is a multidisciplinary subject with 2 UG and PG courses, namely food and nutrition and human development. And there are 26 posts in our university. Since 2013, there has been no recruitment and the department is facing academic problems due to shortage of teachers. At present, there are only 12 full-time faculties, 4 food and nutrition, 6 human development, 2 music and household. Under such circumstances, I strongly recommend the appeal of the faculty members who have proposed the name of Professor Shanta Datta Dey as honorary adjunct faculty in food and nutrition course at the Department of Home Science. I shall be highly obliged if you kindly consider the appeal of the majority of the teachers of our department and take necessary action. Lordship will kindly see on top. This is handwritten, Honorable Vice Chancellor, kind instruction solicited. This is a signature of the registrar. And Your Lordship will kindly see on the other corner, the registrar. I am empowering you to take the decision. That is the signature of the Vice Chancellor. So, Your Lordship, the registrar has been empowered to take all decisions. I will not trouble Your Lordship with anything at present in my affidavit in reply. I'll place before Your Lordship the affidavit in opposition. Lordship will kindly come to page 22. This is, Your Lordship, the meeting of the syndicate held on 29th October 2024 at 3 p.m. And these are initially, Your Lordship, the agenda of 29/10/2024. Lordship will kindly come to page 35. 35. Okay. Lordship will kindly see page 35. These are items circulated on the table. These are 71 to 79. All these items. And then Your Lordship will kindly come to page 57. Page 57, Your Lordship. Short resolution of the syndicate dated 29/10/24. Item 81, which does not form part of the resolution of the main resolution, Your Lordship, on the list of resolutions dated 3/12. Lordship, this is page 57, approved. Lordship has got it. Approved by the Dean, PG Studies Home Science, pro forma, first copy to be retained by the department, Syndicate, Calcutta University, dated 29th October 2024, short resolution of the syndicate. Item 81, page 57. Item 81, short resolution of the syndicate dated 29/10/24. Items placed on table, item 81, to consider the proposal and then be accepted and approved. The registrar, Your Lordship, will kindly see the resolution. Resolved that the proposal of the Dean Faculty for PG Studies in Home Science regarding appointment of Professor Shanta Datta Dey as honorary adjunct faculty in food and nutrition in the course of department be accepted and approved. And thereafter, the registrar be entrusted to communicate necessary information to Professor Shanta Datta Dey at an early date. The Honorable Vice Chancellor did not take part on the deliberation of the above mentioned item, and therefore the Dean Faculty Council for PG Studies in Home Science chaired during the deliberation of the above item. So this is the resolution taken, the short resolution. And your Lordship will kindly come to page 61. This is a resolution dated 4th December 2024. Page 61, Your Lordship. Then Your Lordship will kindly come to page 62 to consider the items 1 to 42. And this is not an agenda in between 1 to 42. So it was not for consideration on the 4th of December. Your Lordship will give me a second. Your Lordship will come to page 89. Page 89, items placed on table. Item 80, to consider the matter regarding transfer of fund to BI so-and-so for other suitable B1 to process bills of these heads, resolved that the matter be accepted and approved. Item 81, Your Lordship, to consider a proposal received from so-and-so, matter be taken out. And item 82, again, a resolution is taken. So, Lordship, item 81, which was placed before the syndicate on the 4th of December, was an item which had already been resolved on the 3rd of December. It was not to be placed before the syndicate at all. It required no ratification. And it was placed and it was said to be taken out. And Your Lordship, after that, my learned friends have not placed the resolution that which was take the matters syndicate resolutions which were there before them on the 27th of November 2025. It is my submission, Your Lordship, that on the 27th of November 2025, item number 2 was not an item which was required for dealing with the appointment of the writ petitioner. It was an item which for formulation of the rules and regulations for appointment of an adjunct professor. I've said it in my affidavit. I am saying it before Your Lordship. So this was the entire matter before Your Lordship. My learned friend, Your Lordship, they have taken this stand. That matter to be taken out means that that resolution has become inoperative. It is not to function. And Your Lordship, the petitioner before Your Lordship since January has not been able to discharge her duties. Lordship will kindly consider whatever the rules, whatever the regulations, Your Lordship will consider this is a department of the university where there is an extreme shortage of professors. And Your Lordship, an adjunct professor is being appointed. An adjunct professor who is not seeking any remuneration. She is going to the university out of her own pocket. She'll come to the university, she'll discharge her functions as a teacher and she'll go back. She's just an educator at heart. She's not seeking anything. And Your Lordship, I'll now place before Your Lordship the reason why an emeritus or adjunct professors are appointed. I'll place before Your Lordship the rules relating to appointment of a honorary adjunct professor.
Can we take it up tomorrow?
Instead of tomorrow, my lord, can it be next Monday, my lord, subject to Lordship's pleasure?
Your learned senior friend will not be available. It is submitted.
I will be back only on this. I'll be available on the 2nd, Your Lordship.
Any day after 2nd, my lord.
Today we are on the 20th,
20th.
and next on the 2nd.
Lordship, because I will not be available.
2nd.
Lordship, may I make one humble submission? Lordship, allow her to, that is my interim prayer. Allow her to take her classes. If it falls from Your Lordship, she'll anyway stop.
The interim prayer was refused.
It was not refused, Your Lordship. That day the matter was taken up. My learned friend asked for 2 days' time to file the report, the opposition. And thereafter, till today, it has not seen the light of day.
No, we have filed our report.
Yes, you have. I said the matter has not.
Kindly tell.
Lordship, allow her to take her classes, Your Lordship.
It will be seeking interim relief in the form of final relief.
Lordship, she is
make my submissions on interim relief.
But Lordship will kindly consider one thing. Also, if it is allowed, if she's allowed to perform her class, give her services. Lordship, they are not going to lose out. It's just the students who will still be benefited. I don't see any reason how the authorities are going to be any way compromised.
How many classes does she take in a week?
Lordship, at present, she's taking, as a guide, she's taking 4 or 5 classes a week. As a guide, she's got her own scholars.
To the best of my information, she is not taking any class at present.
She goes to guide her students.
Yes, she says guide.
Guide, I'm not taking
because
classes.
You are not allowing her to.
I said as a guide. As a guide, she's going. Yes. As a guide, she's going to her scholars, going there 4 or 5.
Let us on 2nd. Well, I'll make my submissions on 2nd.
No, she is yet to complete her submission.
Very well.
That is the reason.
Lordship, only a person wants to teach the students, Lordship.
My learned friend is seeking interim relief at this stage after, I think, 6 or 7 months from the date of filing of writ petition. Then, my lord, kindly hear me, because this
will the university be prejudiced in any way if he goes and teaches?
I tell you, Lordship, my lord, we do not stand in the way. Later function as a temporary teacher.
Lordship, guest teacher, they are supposed to remuneration. We don't want remuneration.
No, we will not give a remuneration. Guest teacher status.
In the status as a temporary relief till we hear the matter.
My lord, kindly, my lord, adjunct faculty, my lord, this will create. I tell you, Lordship, my lord, kindly bear with me for 5 minutes for your Lordship's kind consideration. Kindly take, my lord, page 20 of the affidavit in reply.
No right will be created. Interim.
My lord, kindly, my lord.
As a guest,
as a guest teacher, my lord, we do not stand in the way.
All right, give something in writing so that she can go at least.
Guest teacher,
she'll be allowed.
She will be allowed, my lord.
Lordship, Lordship will not. It will not create any precedent. Let her go. Let them allot certain classes.
We will do one thing. Whenever the classes are available for as a guest teacher, we will allot the classes to her.
That is the issue. They will never have classes for a guest.
So we will, my lord. We will come back to your Lordship on 2nd. If we come back to your Lordship on 2nd, and even if it's seen that we have not allotted any classes as guest teacher.
I want something from your side so that she also gets to know what is something in writing.
Very well, we will do that. We will do that. As guest teacher, we will do that.
All right.
Yes, I've got.
Lordship, let them allot classes to her. As a professor without giving it any nomenclature.
As guest teacher, my lord,
Lordship, let them not engage her. Let them allot classes as a guest professor. Why the engagement?
8th of October, kindly mark the dates. On 20th.
The next day. Dates and everything on merits we'll hear on the next day.
In the meantime, let her allow her to take classes just as a professor.
Tomorrow, please come with something in writing. We'll keep it on record. And then we fix for hearing on the next day.
My lord, kindly take it from me. By tomorrow morning, I may not be able to attend the hearing tomorrow, but Mr. Chatterjee will be there. He will hand over
something in writing so that the petitioner gets.
Yes.
And then we will hear the matter.
The petitioner is omnipresent, omniscient, and
whatever.
omnipotent in the university.
Whatever. But then let something be there if she intends to teach.
My lord, when it has fallen from my lord, we will. Guest teacher, she will be allotted.
Lordship, without any nomenclature, let the classes be given. Why the nomenclature guest teacher?
This guest teacher nomenclature is also a temporary. Just let her go, and we will hear the matter is clear. So no right is being created either as an adjunct or a guest. Let her go.
My lord, we want this matter to be decided by your lordship.
All right.
Issue the necessary letter by tomorrow. We will come with a letter and produce that before your lordship.
Tomorrow you won't be available, so
Lordship, I will be available. I'll leave in the evening.
All right.
So
tomorrow
I'll come
morning
in the
you'll be
morning.
there.
I'll be here in the morning.
Mr. Chatterjee will be here.
I'll be here in the morning.
Guest teacher. Lordship,
Yes. Please come.
Mr. Chatterjee, don't hear me tomorrow. Limited to that only tomorrow.
I won't hear. I won't hear the petitioner also. It is only she won't be there. Interim.
Yes. As an interim,
and we will here decide
she
the
will
issue.
kindly indicate that we will come back with some kind of letter.
Yes. Learned advocate appearing for the petitioner commences argument. The as the matter is still as the matter will require some time to be adjudicated, comma, as an interim measure, comma, for the interest of the students, comma, the university may take a decision to allow the petitioner to teach the students. Stop. Release the matter tomorrow.
Well, as guest teacher, my lord. That
I am keeping
not
it
giving
blank.
nomenclature.
I am only mentioning for the best interest of the students.
Yes, we will
take
do.
a decision.
My lord, may I
as
just
to
make
how.
one humble prayer, my lord? If your lordship makes it clear that this will not create any ethics. Yes.
Tomorrow let it come.
Yes,
I'll keep it on record and I'll make it clear.
Yes.
তারপর কি বললাম? শেষটা কি বললাম? ঠিক আছে? Let it come tomorrow. Let
I'm
us see
grateful,
what
your lordship. I'm grateful, your lordship.
Mr. Chatterjee will be here. If
Yes,
I am here, I will
no
assist your
issues,
lordship.
No issues. এটা রাখবো।
Second is a Sunday.
Third.
Tomorrow is a working day. I'll fix the next day.
Next day.
I'm grateful,
Tomorrow.
your lordship.
Grateful, man.
My lord, non-prosecution in this matter, client communication.
I am appearing for the respondent number 9. Right.
The writ petitioner is a training institute. And the person who is withdrawing it mentions that he wants to withdraw the matter for personal reason. Training institute and personal reason I cannot understand.
My lord, assistant secretary, he is.
Yes, it's a training institute. What personal reason can a training institute have? Who are you for? Who are you representing?
Respondent number 9, University Grant Commission.
University Grant Commission.
9.
Respondent number 9. There is a pharmacy council also. You had impleaded one learned advocate in the writ petition as party. There must be some reason.
No, my lord, advocate on record is another.
No. Where is the advocate on record?
She could not come to court today. This is
Bring
personal.
the advocate on record. A handwritten communication dated 17th July 2026, allegedly signed by one Mithun Barik, with request not to press the writ petition has been placed before this court. Stop paragraph. The advocate on record is not present today. Stop. When will he come?
Tomorrow, my lord.
Tomorrow? In that case, you bring this tomorrow? Or if you want any other date, I'll record an order, I'll place it on the next date. When?
My lord, 23, my lord.
Huh?
23.
23 তারিখ বৃহস্পতিবার, Thursday 23rd, released on to be mentioned. Written instruction written with the records.
For the petition of lordship led by Mr. Shamim Ahmed.
Why to be mentioned?
Merit list already be published in the Jadavpur University, Your Lordship. One documents verification is on 24th.
Who's for the bird one?
My lord, actually, I have been directed by your lordship to take instructions, my lord.
Yes.
My lord, I got instructions. My lord, but I am praying unconditional apology since it hasn't been ceased.
That doesn't matter. What does the instruction say?
My lord, lordship kindly see the instructions and I am coming with the relevant paragraphs. Lordship at a glance. The relevant paragraph is the paragraph 5. That is start from my lord, lordship kindly come at third line. The records indicates.
Give me the paragraphs, I'll read it. Paragraph 5 and?
Paragraph 5.
And
paragraph 10, my lord. Paragraph 10. I shall make my submission.
And what else? Only these two paragraphs?
Yes, and paragraph 10, my lord. Here is the policy involved, my lord.
I have seen that. Anything else?
Policy of the government.
Anything else?
No, my lord.
No? All right.
And paragraph 14, lordship.
14? Yes, I've seen that. All right, see. Did you get a copy of the instruction? All right. Hand over a copy so that she also gets to know.
My lord, I have only one copy, my lord.
Make a photocopy and give. And I'm reading it out for your benefit. That is, according to the college, you did not give any intimation after 2016 as to why you are leaving. And there are certain prescribed formalities which you are required to comply, which you have not complied. And the formality which is mentioned is that a bond was signed at the time of taking admission, that in the event the candidate resigns or discontinues, then the candidate shall be liable to pay a sum of rupees 1 lakh to the government college in terms of the government order dated 25th of October 2010. So there is some formalities which you are to comply, and then only the documents possibly will be released.
Lordship.
Right?
Lordship, to address your query, the first question is, I have made some representation before
Maybe
the college
representation is not the only thing. If there are formalities to be complied, you have to comply the formalities. Then
I have made a representation in page number 37. Your Lordship.
Representation will not do. There are formalities to be complied.
Yes, I understand, but college did not convey us any kind of formality.
Now you have got to know. You were sitting idle for 8 years. And overnight, this urgency has cropped up because all on a sudden you thought you're going to start your education all over again. So what is to be done? Comply the formalities? There is a requirement of issuance of a migration certificate, a deregistration certificate, and there are other paraphernalia. Until you comply the formalities, it cannot be done.
Lordship, in the meantime, can I apply for the Xerox copy of my original documents in the Jadavpur University in the document verification process? If your
My
Lordship
lord,
allows
is
so.
their own reading in paragraph 11. My lord, for verification, original documents are required. They have themselves pleaded that. My lord,
How
this will be
the
very-
list has been published. When will the verification process take place?
My lord, there are
in
possibly
philosophy
he has
course?
applied for 3 subjects. In 2, one of the date is 24th and the other one possibly on 28th. My lord, but my lord kindly considers para 10 and para 11. It is very difficult for us because the verification will require original documents as per the my lord notification.
Please
They
come.
could acquire this before 23rd immediately if they apply, and my lord the Burdwan University takes steps immediately, then my lord possibly they can come before us.
Peruse the instruction forwarded by the principal, Burdwan Medical College. Signed on 15th of July 2026. It appears therefrom that the petitioner, it is the stand of the medical college that the petitioner discontinued his MBBS course after passing the second professional MBBS examination on or about February 2016 without any intimation to the college. Stop. Paragraph. The petitioner did not comply with the prescribed formalities for discontinuation. Stop. Paragraph. The college contends that at the time of admission in the MBBS course, every student is required to execute the prescribed admission bond in accordance with the government policy. Step. The bond mentions that in the event a candidate resigns or discontinues the MBBS course before completion of the prescribed tenure, the candidate shall be liable to pay a sum of rupees 1 lakh only to the government college in terms of the government order number, paragraph 10. Stop. The college contends that it is the liability of the petitioner to act in accordance with the admission bond. Stop. Paragraph. Learned advocate representing the petitioner submits that he intends to pursue education in a different course in Jadavpur University. Stop. The petitioner accordingly applied before the university and stood selected in 2 courses. Stop. The scheduled date for verification of the verification of documents for admission in the subject course is on 24th July 26 and 28th of July 26. Stop. The classes are scheduled to begin on 29th of July 2026. Stop. You want only philosophy?
I want, there is comparative literature also for.
Where
that
is this
that,
page?
28 July.
So 2. And this philosophy classes starts on the 29th and that class starts on?
29. 29.
29th. Stop. Prayer has been made by the petitioner to prayer has been made by the petitioner to direct the Burdwan Medical College to release his original educational certificates. Stop. Paragraph. When will you? There is a bond which mentions that you are to pay 1 lakh of rupees and certain other paraphernalia.
That is not beyond the scope of UGC circular.
If this is to be heard and decided, the matter is going to take some time. Choice is yours.
This principle has already been decided by a coordinated bench of this honorable court.
I need to hear this bench has
So far, payment of bond is concerned, let it be subject to final outcome of the petition.
For the time being, you pay. Whether you will ultimately succeed or not, if you succeed, the money
difficult for this unemployed and a student to pay 1 lakh.
Very well. Then it will be open for the petitioner to take steps in accordance with law for getting his.
Let me come back then tomorrow with instruction.
Stop.
Without client's instruction, it's difficult for me to submit.
Release the matter for further consideration on. See, today is 20th. I can post it on the 27th. By that time, everything will be over. And the court has left it upon you to take a choice. What to do, whether to act in accordance with the bond or not. Choice is yours.
Bond is of.
Let a copy of this instruction be forwarded to him so that he also gets
May I make this submission? Let this be decided finally on 27th. On 27th.
27th or thereafter. I cannot say immediately whether 27th is a Monday. Today is Monday. Next Monday I keep it just to see what is happening. Now I'll fix up a matter for hearing as per the convenience of the court.
Question of law. I don't think any affidavit is required to decide.
Very well. That the authority will take a decision. Here the submission.
In the meantime, may I submit this? Let the Jadavpur University take my admission subject to production of the documents subsequently. But it's difficult for a student to pay 1 lakh, particularly.
I do not know.
Huh?
Relist on 27th. ঠিক আছে? All right. Take back this.
দেখো কিছু করার নেই আসতে পারলাম না
এর আগেকার এটা আর্জেন্ট করে দেবেন এর আগের দিনও একটা বোধহয় অর্ডার
May I please your lordship, my lord? I'm for the petition.
I am for the state respondent.
Yes.
This matter,
Answering respondent.
my lord, the answering respondent would be the university.
University of Calcutta.
University of Calcutta.
Yes.
My lord, kindly sees page number 19. Kindly sees page number 90. This is an EWS certificate issued by the concerned authority in the year 2025. That's valid for 2025-2026. So that ends on 31st March 2026. Now, my lords, I had applied for the joint entrance examination on March 11th. Kindly sees the application. That's at page number 35. So, my lords, as on the date of my application, I have applied under general EWS category.
Yes.
My lord, the application date is at beneath. The application form is generated on March 11, 2026. So, as on the date of my application, this EWS certificate was valid. Thereafter, my lords, I had cleared the examination with flying colors. My lord, that is at page number 38. My report.
Yes.
My EWS rank is 239. For engineering and for pharmacy, it is 240.
Yes.
Thereafter, my lords, page number 35 is the schedule for the first round allotment, the second round allotment, the third
Not
round allotment.
35, some other page.
Page number 39.
39. Yes. Yes.
In the meanwhile,
Hmm.
my lord kindly sees page number 46. On 31st of May 2026, I have applied for the EWS certificate of this financial year.
Page number 46.
Page number 46.
Why 30th of May you applied? Your certificate expired on 31st of March.
My certificate expired on 31st of March. In between, my lords, due to the election duty, my lord, the ADM wasn't available. So
You
far as
are
my...
required to make online applications. Your submission is absolutely incorrect.
Now, my lord, the only concern is so far as... Now, I appeared in the first round of counseling. My lord, kindly sees page number...
This page 39 result.
Yes.
When was the joint entrance result published?
The joint entrance result was published on
18th of June 2026.
18th of June, yes.
Right. You knew that you were applying.
I've applied before that.
Reserved. Maybe before that, but you knew that you were applying under the reservation category. You want reservation.
Yes.
So for that, you need a valid certificate.
No, that is what something was that was not in my knowledge because there was no notification to this regard. Now a notification comes on 29th of June. Kindly sees the notification. Kindly, it starts from page number 20.
Yes.
Page number 20, the notification is of 29th of June. That is after I have applied for the EWS certificate.
After you have applied, you applied on 30th.
30th of May. This is on 29th of June.
Right. Yes.
Now, 29th of June notification, page number 26.
Yes.
Rule 7, sub-rule C says that I have a valid document as on the date of verification.
Page number 26, you say?
Page number 26, Rule 7, sub-rule C.
Sub-rule C, all documents must be valid as on the date of verification.
Now, when does this come? This comes on 29th of June 2026 and that to 8 days prior to the beginning of the first counseling session. So this rule was never there before. This is a new notification that has come up. Thereafter, my lords,
what does the notice regarding applying say with regard to reservation?
My lord, the notice regarding application says that is not annexed. It says that as on the date of application, that must be a valid document, which I had already provided.
And not on the date of the counseling
No, it does not
certificate?
say anything of that.
It doesn't say.
It doesn't say.
All right.
Now, the only difficulty is, my lords, that page number, kindly sees page number 40.
By the way, tell me, 30th of May you applied and still now you have not got it?
I have not got it because there the policy is that the authority must produce issue the certificate within 60 days. Within 60 days. And now they take time by heart. That's a separate issue. So far as my personal knowledge is concerned, the ADM has said that they'll be issuing the document in the next 7 days at the earliest as possible. They're much considerate about my case. Now,
Yes.
page number 40 is where I appeared for the first round of counseling. My EWS category has been cancelled, and towards the bottom of the document, my lords, the category changed from general EWS to general. Another question is, the policy is for document verification, not for resubmission of documents, fresh documents. So whether the authority will or has the power under the notification to call for fresh submission of a new document, or the authority will verify the documents which were valid at the time of application, is the question. Now, that's not the point that I'm trying to make. What I'm trying to make is, my lords, for no fault of mine, I have not been allotted a seat. My reservation has been cancelled. My reservation has been cancelled to a general category, and I might not secure a seat. They are not allowing me, they have not allowed me to appear as a EWS category in the second round as well. Third round starts tomorrow. Second round's merit list appears tomorrow. Lord, may I pray? I've prayed that in the second round, may I be provisionally given an allotment. Let the additional district magistrate issue the certificate. Immediately thereafter, I'll produce the certificate. If I cannot produce, let a time frame be fixed. If I cannot produce, may my allotment may be cancelled. But may I be provisionally allotted?
I do not stand in the way, my lord. These are students' admission, my lord. My lord, by large, my lord, I don't stand in the way, but the policies, my lord, your lordship has decided the issue time and again that he need to have a valid certificate. As on date, he does not have a valid certificate. Only kindly take a judgment decided by your lordship only.
No, it's all right. I can understand.
As on date, my lord, your lordship has held, allowing him petitioners will be depriving others. My lord did not entertain the writ petition and dismiss the writ petition in Kamalakanto Maiti. Your lordship considered everything. Supreme Court judgments were cited. And your lordship observed that the purpose of reservation is yearly basis, annually.
Especially EWS.
EWS,
Had
absolutely.
it been the caste certificate,
In this
it would have
judgment, my
been
lord will find your
different.
lordship distinguished. SC, it was argued that SC certificate was not provided. Your lordship distinguished that fact, saying EWS categories, you have to have a certificate while you're making an application. And my lord, your lordship sees the page 26, your lordship has seen that the page 26, my lord, your lordship has seen. It says
valid on the date of verification.
Right. So, my lord, one test that your lordship always put the petitioner is, my lord, allowing the petitioner if prejudice or, my lord, discriminates like students. My lord, your lordship has never allowed that. My lord, by large, if the seat is vacant, my lord, and your lordship decides I don't have a problem, but your lordship has decided otherwise, my lord will find that from this judgment. Should I, my lord, hand up this, my lord?
Now, the only distinguishing factor from this judgment is the notification came 8 days earlier.
Forget
No.
about the notification. You
Difficulty
are claiming this.
Yes, difficulty is you knew your certificate expires on 1st of April. If you are so interested with obtaining
There was no
reservation,
law.
very well, we will decide the issue.
Right.
Let the law be there.
Grateful, my lord.
The petitioner seeks reservation in admission to the undergraduate courses in engineering, technology and architecture. Stop. On the date of making the application, he possessed a valid EWS certificate. Stop. The certificate was valid till not till for the year 2025-2026. Stop. Validity of the said certificate expired on 31st of March 2026. Stop. The petitioner applied for obtaining fresh EWS certificate on 30th of May 2026. Stop. The said certificate is yet to be issued in his favor. Stop. In the meantime, the petitioner intends to participate in the counseling process in the reserved category. Stop. As the petitioner does not have a valid registration, valid EWS certificate in terms of the notice dated 29th June 2026, he is being treated as a general category candidate. Stop. The petitioner is aggrieved by the same. Stop. He prays for a direction upon the Joint Entrance Examination Board to allow provisional allotment of seat to the petitioner, and if the petitioner ultimately fails to produce the EWS certificate, then to cancel such allotment. Stop. Paragraph. Learned advocate representing the state respondent submits that as per law, the e-certificate, that the EWS certificate can be issued within a period of 60 days from the date of making the application. Stop. The petitioner has applied for the certificate on 30th May 2026 and 60 days time period is yet to be over. Paragraph. Learned advocate representing the University of Calcutta submits that the candidate ought to have a valid EWS certificate on the date of verification. Stop. Paragraph.
Even as on date, he does not have that. I will kindly put in.
Even though, continue, even though the petitioner may have a valid certificate on the date of making the application. Stop. Upon hearing the submission made on behalf of both the parties, it appears that, admittedly, the certificate of the petitioner expired on 31st March 2026. Stop. Had the petitioner interested to continue his candidature in the reserved category, he ought to have applied immediately for. He ought to have applied either during the validity period of the said certificate or immediately on the date of expiry. Not on, immediately on or after the date of expiry. Stop. Paragraph. The petitioner applied for fresh EWS certificate only on 30th of May 2026. Stop. Statute provides 60 days time to the authority for issuance of EWS certificate. Stop. The said time period is yet to be over. Stop. Next. In view of the above, comma, hearing of the writ petition stands adjourned till 3rd August 2026. Stop. The concerned authority will take steps to consider the petitioner's application seeking grant of EWS certificate in his favor in accordance with law. Stuff. Learned advocate representing the state respondents shall revert with necessary instruction on the adjourned date.
Lord, the third round of counseling, my lord, the merit list comes out on 28th.
No, this I won't keep. No use. You come back on the 3rd and tell me whether very well. If it is done within 7 days, petitioner will get the benefit. On 3rd, I'll keep it.
My lord, the counseling by that time gets over. My lord, the
Release
counseling.
this urgent motion.
My lord, the counseling by that time gets over. The last round.
Be done.
In any ways, my lord, the matter would be infructuous. There would be no seats available.
Sorry, sir, I cannot help you.
My lord, kindly allows me to participate as an EWS category in the 3rd round provisionally.
Without a valid certificate.
My lord, that's what a provisional. I'm seeking for a provisional allotment, my lord. Kindly allows me to participate, at least. Otherwise, the writ petition becomes infructuous.
The petitioner for permitting him to participate in the process of counseling as EWS candidate provisionally cannot be allowed, as the same would amount to discrimination in respect of several other similarly placed candidates who may not have a valid EWS certificate on the date of verification of documents. Item 4.
My lord, if the judgment, if the order could be uploaded in the meanwhile today.
Well, I appeal for the petitioner.
Sir,
This is the matter.
Post-institute.
Well, this is the matter regarding reversion of employees. We have challenged the action. In a similar writ petition, the coordinate bench has found favor with the petitioners. The impugned order of reversion was set aside. My learned friend's client has preferred an appeal. That appeal is pending consideration. I have seen the last order, but I'm not on the main matter. I understand since the Honorable Division Bench is in session of the matter, perhaps it is again judicial propriety to proceed with. But I have taken out an application. Your Lordship, please to grant us liberty to take out an application. During the pendency of this appeal, out of 12 petitioners, 5 have superannuated. From their terminal dues, gratuity, leave encashment, almost entire sum has been withheld. Their client's contention is that this amount has been withheld, not recovered. So it will not be hit by Rafiq Masi and this last lately Jogesha Shahu. My respectful submission, if the ultimate action is ex facie bad or not permissible, if recovery is not permissible, withholding the amount in anticipation of recovery is also not permissible. So I have taken out that application. Pleadings are complete.
Won't that touch the main matter?
It will not. It will not. The judgment that I'm relying upon, in Jogesha Shahu versus district judge.
What's the position of the appeal?
This is the two orders passed in the earlier two occasions.
The
Lordship may kindly peruses the 7th of July's order.
Tell me what is
affidavit in opposition file.
8th of July is the fixed for a hearing.
28th?
2/8.
2/8.
Yes. It's fixed for hearing.
Before the appeal court?
Yes.
28th is next week only.
My lord.
I'm not pressing for the appeal, the main writ petition. The
I understand.
cancer patient, cancer survivor requires something.
Is there anything that is admitted dues of these superannuated? Nothing.
It is touching the main merits of the order passed by the learned single judge, which has been assailed in appeal.
don't go to the single judge's matter. The thing is, there are certain employees which the petitioners say that have superannuated, and they need finance for medical treatment and everything. Is any amount there
Milord,
which
there
can
is
be
no
released?
admitted amount. They have, Milord, got excess, Milord, to their benefit.
And
Milord.
you want to withdraw
Yes,
those?
yes. It is, Milord, Milord, in excess of their actual entitlement.
Petitioner says that you cannot do that because if the employees retire and they have enjoyed the money for so many years, then how can you?
Milord, if the learned single judge's order, Milord, is sustained by the appellate court, Milord, then, Milord, they are entitled. Milord, we cannot recover. Milord, if it is set aside, Milord, then, Milord, Lordship kindly peruses, Milord, the earlier occasion, Milord, the Honorable Division Bench has passed an order, Milord, to fix, Milord, the liability of the erring officials of the institute. Now, Milord, there will be, Milord, different, Milord, scenario altogether. It will create, Milord, multiplicity of proceeding. If we, Milord, not withheld, Milord.
I understand. This is the reason I was not trying to enter. I was moving in the periphery only to ascertain whether there is any admitted dues which these employees can be
Milord,
paid.
they have
No.
got in excess.
They have got in excess. So whatever their dues they have got, and they have been paid in excess.
My lord.
My lord, may I just try to satisfy your lordship? My lord.
No,
My lord, one this judgment, my lord. One paragraph.
No.
My lord, one paragraph, your lordship. My lord, one paragraph that is especially long, wrong. Pendency of appeal will not prevent, my lord, allow them to recover. Let Supreme Court has settled this issue.
It has been brought to the notice of the court that the issue in question, which is pending consideration before the Honorable Division Bench, has been fixed for hearing on 28th of July 2026. Stop. Learned advocate representing the petitioner submits that there are several employees who have superannuated from service and would require finances for immediate medical treatment. Stop. Prayer has been made to direct the authority to disburse the admitted dues so that the superannuated employees may continue with their medical treatment. Stop paragraph.
Let have also challenged the
Also been submitted that the recovery process would be expressly bad in law as the employees have already superannuated from service. Stop paragraph. As it appears that the appeal in question is due to be considered for hearing by the Honorable Division Bench, is due to be heard by the Honorable Division Bench next week. Accordingly, the court is not inclined to decide the interlocutory application filed by the petitioners. Step. Let the matter appear in the list once again on 3rd of August 2026.
may I just show one paragraph, your lordship. Well, then in that event, if it is not taken up, in the meantime, may I just have liberty to press this application on the next day? Because they are in.
It is. Are you not pressing
there is
it?
no stay. There is no stay, ma'am.
Are you not pressing it? You are pressing.
I am pressing this application.
Yes, you are.
But that appeal will not stand in the way of your lordship too.
Nothing.
Grateful.
Grateful, your lordship.
In this matter, your lordship directed me to take instruction from the Principal Secretary, Department of Information and Cultural Affairs. My lord, I am praying for just 2 days' time. My lord, kindly take it up on Thursday, my lord.
What is the position?
Direction upon the state as your lordship will kindly.
What is the position? Ground reality.
Ground reality, my lord, they are still not allowed to work.
Not allowed to work?
Some of them have left Calcutta. One of them, I have information.
Compelled to leave.
Compelled to leave Calcutta, my lord. She is, I believe she's working in Delhi.
State Council, please take note of the concern of the petitioners. There were quite a few, and the court had passed order that their right to life and livelihood, 19 and 21, should be protected. So the Principal Secretary, Department of Information and Cultural Affairs ought to take immediate steps
to protect their livelihood.
At least a report can be filed on the next day on behalf of the state, because there was a direction upon the state
take
on the last occasion. So,
Well, then kindly grant me some time. We will file report.
because what are the steps that are being taken?
Please come, learned advocate representing the petitioner submits upon instruction that the petitioner is yet not permitted to function independently in the film and television industry in this state. Stop paragraph. The court time and again passed direction upon the state respondents to ensure that the right to life and livelihood of the petitioner is not infringed in any manner whatsoever. Stop. The authorities ought to take steps in terms of Article 19 and 21, Articles 19 and 21 of the Constitution. Stop. On the prayer of the learned advocate representing the Principal Secretary, Department of Information and Cultural Affairs to revert with necessary instruction, hearing of the contempt application stands adjourned. Stop. Release the matter on 4th August 2026. Fortnight's time is granted to you. Please ensure.
My lord, instead of 4th, can it be on 5th or 6th?
Acha 5 Tarikh, 5th. All right.
Yes, ma'am.
These persons should be allowed to function freely without interference from any corner whatsoever.
Because, my lord, some of the contemners who have been made contemners, they are moving freely in the entire site. So that has become a bit difficult.
Let us see what the report comes and then we can pass necessary orders. If you want to file an application in the meantime, an affidavit disclosing new facts, the submission that they are moving around freely for which you cannot work, you can bring.
That I shall take instructions.
Take
if they
instruction.
can give certain documents, because without
Yes.
documents I will not be able to file.
Right. And court also cannot pass order in air.
Lordship.
There has to be something on record.
I shall take instructions, and if they instruct, then we can file a application.
All right. 6 also same order.
6, 5 and 6.
Seven. Falcon.
Item 8.
Or 8 all.
Right. 7. Well, petitioner lordship fixed this matter today. Matter can be resolved. Petitioner was a single subject teacher. She was prevented on the ground of single subject teacher. It was challenged before the Honorable Single Bench. Honorable Single Bench was pleased to proceed with 3rd January notification, but put a rider of willing teacher. That was assailed before the Honorable Division Bench. Honorable Division Bench clarified that willing teacher is not to be read in the notification, page 106, second paragraph. After that, DI made the communication, again writing willing teacher. That was challenged before your lordship, page 106, second paragraph. Your lordship, kindly take page 108, last paragraph.
Yes.
That again, that willing teacher in ignorance of the order of the Honorable Division Bench, that I challenged before your lordship. In the meantime, after filing the writ petition, possibly they have understood it and sent it to the commission. DI has sent it to the commission for taking.
So right now it is pending before the
commission. Only my humble prayer is, my lord, that observation may be dealt with properly, my lord, that willing. This is your lordship's order.
Since, my lord, they have forwarded it to the commission, so, my lord, no grievance.
No, that observation is still there. It might affect the decision making of the commission because it has gone from this side.
Please come.
Second page, my lord.
The petitioner seeks transfer. Stop. It appears that currently, his application seeking transfer stood rejected on the ground, rejected on repeated occasions on the ground that she is a single subject teacher. Stop. Paragraph. Today, it has been brought to the notice of the court by the learned advocate representing the petitioner that the District Inspector of Schools, Secondary Education, Purba Mednipur, with a communication dated 5th May 2026, has forwarded the application of the petitioner seeking transfer to the Chairman, West Bengal Central School Service Commission for passing necessary order. Now, for taking necessary action. Stop. Paragraph. The prayer of the petitioner is currently pending consideration before the School Service Commission. Stop. Paragraph. Learned advocate for the petitioner relies on the order passed by the court on 3rd November 2025 in WPA 21342 of 2025 within bracket Amitabh Pal versus State of West Bengal and others, wherein the court decided the manner in which the application of single subject teacher is to be considered by the authority. Stop. Paragraph.
Paragraph 6.
The court took note of the order passed by the Honorable Division Bench on 8th August 2024 in MAT 1218 of 2024 with CAN 1 of 2024 within bracket Gokul Chandra Mullik versus State of West Bengal and others, and the order dated 31st July 2025 in FMA 995 of 2025 with CAN 1 of 2025 in the matter of Rupak Duha versus the State of West Bengal and others. Stop. The court directed the authority to consider the petitioner's application for transfer and dispose of the same in accordance with law, irrespective of the fact whether any alternative arrangement could be made or not. Stop. The resultant vacancy on the transfer of the petitioner shall be filled up in the manner as directed by the Honorable Division Bench in the matter of Rupak Duha within brackets Supra. Stop. As the issue has already been decided by the court, accordingly the instant writ petition stands disposed of by directing the commission to take a decision on the petitioner's prayer strictly in line with the observations passed herein above at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. All consequential steps upon consideration of the petitioner's prayer shall be taken immediately thereafter. Stop. Writ petition disposed.
I'm grateful to Lordship. Much obliged.
Are you there in item 9?
Yes.
It will be temporarily passed over because the file is in my chamber. It's to come. Right? Just wait.
10 I am for the petition. Pursuant to the earlier direction, I have sub upon the learned advocate for the state respondents. My lord, by the writ petition, the writ petitioner prayed for a direction upon the authority for approving his service with effect from 1st May 2000 in terms of the earlier direction of a coordinate bench, which was approved before the division bench and also before the Honorable FX Court. That is the case for approving his service with effect from 1st May 2000, but they have approved with effect from 17th February 2004 instead of that.
1st May 2000, you want it
Direction.
from that date.
That was the direction of a coordinate bench of
Please
this
show
court.
me. This is the issue.
That is the only issue.
All right, please show me the order.
My lord, order starts from my lord, page 32 is the operative portion. The last paragraph. Paragraph number 5.11.
Therefore, petitioner's appointment assistant teacher be approved in accordance with law from 1st May 2000.
That I have stated.
Yes.
But that this order was my lord, carried before the division bench. That was my lord, affirmed. That order I have annexed the last portion of that order, page 42. 42 operative portion, 43. And appeal fails, page 44.
All right,
My lord,
44.
that order also assembled before the Honorable Apex Court, along with other my lord, writ petition, page 45, the order of the Honorable Apex Court, and my civil CA number is 7902 2010, page 46. That civil appeal also dismissed.
All right.
My lord, what they have did next, they have done page 51. They have approved as it appears from that
51.
51.
Yes.
As it appears that my date of joining has been given 17th February 2004. Now, basic on that, they have released my lord my other benefit, including pensionary benefit, because in the meantime I have retired. Prior to my lord approving my appointment, I have retired in 2015, and they are releasing, treating me as my date of joining or approval 17th February 2004. But I am praying for my lord my approving with effect from 1st May 2000 in terms of the earlier direction, and releasing the consequence benefits.
Consequential benefits would mean
Salary, etc.
Salary. You had already worked. You had worked.
Yes,
and
yes.
you have received your salary. Why salary for the second time?
No, the salary in terms of that, well, approving that is a different consequence. When my approval appears from 1st May 2000, subsequently my salary increased.
Subsequent increase is different.
The benefits will automatically increase. The
Benefits means the notional benefits you will get.
other benefits,
What are the other benefits?
well, the notional benefits,
Get salary you already been
the benefits of ROPA, etc. well, that also may approve.
ROPA benefit you will
Yes,
get.
yes.
It is not the salary benefit, you will get the ROPA
The
benefit.
enhancement of the salary subsequently enhanced in terms of the ROPA, etc. Other benefits, that I am also.
State respondents.
My lord, the last, my lord, last occasion, I should have taken instruction, my lord. And my lord, on 2006, my lord, Honorable Justice and his lordship then was directed the responsibilities to approve the petition appointment as an assistant teacher in the social science group, my lord. But there are already 2 teachers who are working in social science group of that school. But
No, no use going back because that order has been confirmed by the Supreme Court. Now you have to approve the service of the petitioner on and from 1st of May 2000. There can be no going back because the Supreme Court has said so.
But my lord, my
no ifs and buts. Nothing doing.
But my lord, as for instruction, my lord, that the approval could not be accorded with effect on 2004 due to the vacancy arising on account of designation of some person on 2004. In the year 2000, there was no such vacancy, my lord. In 2004, the vacancy.
Can that be gone into by this court after the order is affirmed by the Supreme Court?
That cannot.
Then what is to be done? All financial benefits which the petitioner should get on and from 1st of May 2000 has to be given. There is no option left to you. When will you take steps?
Time is required, my lord.
Who are you representing?
Both, nothing to say.
No say. Please come.
1 month time and 4 weeks is required minimum, my lord.
The petitioner is aggrieved as the state respondents issued the letter of approval of appointment in his favor on and from 17th February 2004. Stop. The petitioner ought to receive the said benefit on and from 1st May 2000 in terms of the order passed by the court on 20th September 2006 in WP number 16046 within bracket W of 2000, duly affirmed by the Honorable Division Bench in AST number 1278 of 2007 with a judgment dated 4th March 2008. Further affirmed by the Honorable Supreme Court on 19th February 2015 in Civil Appeal number 7902/2010. Stop. Despite the order passed by the learned single judge, duly affirmed by the Honorable Supreme Court, the authority went on to accord approval of appointment of the petitioner on and from 17th of February 2004. Stop. Paragraph prayer has been made to direct the respondents to grant all financial benefit to the petitioner after taking into consideration his date of approval as 1st May 2000. Stop paragraph. Learned advocate representing the state respondents seeks to urge that as there was no vacancy at the subject point of time, the petitioner's service could not be approved on and from 1st May 2000. Stop paragraph. The court is of the opinion that as the date of approval was adjudicated by the learned single judge, duly affirmed by the Honorable Division Bench and the Supreme Court, accordingly, at this stage, there is no scope on the part of the authority to reopen the issue all over again. Stop. The authority would be bound to treat the date of approval of the petitioner as 1st May 2000. Stop. The petitioner would be entitled to receive all benefits upon taking into consideration his date of approval as 1st May 2000. Stop. Next. The petitioner has since superannuated from service and he is receiving his terminal dues. Upon taking into consideration his date of approval of appointment on and from 17th February 2004. Stop. The same is contrary to the direction passed by the court. Stop. Next. In view of the above, the instant writ petition stands disposed of with the direction upon the District Inspector of Schools, Secondary Education, South 24 Parganas, to accord all financial benefits to the petitioner after taking into consideration his date of approval of appointment as 1st May 2000. Steps shall be taken in the matter at the earliest, and the financial dues of the petitioner shall be released positively by 30th of October 2026.
May I pray for adding the interest part, my lord?
When did you retire?
15, 20.
2015?
It has been released 2023. After 2024. And after
As the petitioner would receive his dues
Make the application 2024.
long
Release the phase.
after his retirement in the year 2020, in the year 2015. কি বললাম? As the petitioner would be receiving. তাই তো বললাম? Would be receiving his dues. Accordingly, the dues of the petitioner shall be paid along with interest calculated at the rate of 6% per annum
But Malan, in this
on and from the due date till the date of actual payment. Yes?
But in the next matter, he's asking for the area. But in this matter, there is no prayer, my lord.
Along with
Here.
interest. My prayer is along with interest. দেখো আছে
Area of what?
Yes,
Next
area-
matter, area of?
Area salary. Area salary. Next matter.
area salary.
Area
No, no,
salary.
in
আচ্ছা,
next
এটা
matter,
এটাই থাকবে।
Next
Next
matter,
matter,
he's
let me
asking for
see.
area salary, madam.
What is the area salary? You please show me.
He's getting the salary. He was getting the salary.
What is the area
no, not
salary?
area salary. My next matter is only prayed for
Next matter,
interest.
madam.
In next matter, my prayer only releasing the interest part, which was accrued from the date of my appointment as fixed by the authority till the date of actual payment.
Then both the matters can be disposed
Yes,
of by
yes,
the
yes,
same
yes.
order.
Same order.
Take this number also. Same order will go down. Both the writ petitions
Fine.
disposed.
Grateful to your lordship.
থাকবে থাকবে যেরকম আছে সেরকম থাকবে উপরে শুধু কেস নাম্বারটা অ্যাড হচ্ছে নাথিং মোর
With grateful to your lordship.
Yes, my lord.
12 is anybody there?
Yes, madam. I am about to.
Is the petitioner there?
I appeal for the school respondents 7 and 8.
Yes. None appears on behalf of the petitioner at the time of call. Petitioners. No accommodation sought. Dismiss for default. Record appearance of all the respondents.
Lordship. 39 for the petition. Lordship. I'm paying interest on gratuity and ADA pension, Lordship, on single PPM. Tied in harness, legal heirs are before you, Lordship.
Interest on gratuity.
As result, area pension, Lordship.
On area pension. 25th of April, the employee died, and February 22, the payment has been made. Where is the
Payment has been made, Lordship, April 2022. My PPO has been issued February 2022, Lordship. After 10 months. The nowadays e-pension, there is take 1 or hardly 2 months. We are applied immediately after employees died, Lordship.
You never know. The authority was not supposed to know that the employee will die on a particular date.
Lordship, that is take 1 or hardly 2 months, Lordship. That is e-pension paper, Lordship.
Maybe. What is the stand of the respondents? Any instruction received? Any instruction received?
We are not appearing, my lord, in this matter.
Not appearing.
I have served, Lordship, freshly.
We can take instruction now.
I have freshly served, Lordship, to the under government leader.
Sir. 17th of July, yes. It has been served in the GP's office.
Then you can take the instruction, my lord.
Take instruction and come back.
Yes,
Please come. Ashun to dekhi, affidavits of service filed in court be written with the records. Stop. The petitioner is the widow of an assistant teacher who died in harness on 25th April 2021. Stop. EPPO was issued in favor of the
Legal heirs, Lordship, legal heirs.
legal heirs on 11th of February 2022. Stop. The petitioners pray for interest on account of delayed payment of the terminal dues. Stop. Paragraph. Learned advocate representing the state respondents is directed to revert with necessary instruction on the adjourned date. Release the matter on 10th August 2026. Right.
In item 14, my lord, I am appearing on behalf of the petitioner, my lord, pursuant to a lawsuit.
There, no instruction.
No, we have been
Not engaged. When did you serve?
My lord, it is 15.
If you lordship take
In the last matter also it was served on the 15th, but then
these two matters, 13 and 14, my lord, we have
no instruction.
we are not engaged actually, my lord.
Not engaged. What is your prayer?
My lord, matter relates to, my lord, calculation of past service, my lord, taking
Right.
note of. Similar to item number 10, more or less. My lord, the petitioner was appointed in the year 8th of March 2001 after proper interview, proper selection process, after approval. But when he moved in 2009 for regulation of his service, then with effect from 2009, his service has been approved by the DI, but not from the 2001. I am praying only for taking my lord, for
Counting the past service.
counting the past service. My lord,
There is a representation. Will that be directed to be
my lord,
considered?
kindly, my lord.
Ajay, please come. Are you still in service?
No, my lord, I have retired in 2022. Well, I'm
22.
my lord.
Then why did you
My lord, in
file the representation in 24?
my lord, prior to that, I have also filed.
Where is it?
My lord, that is page 35, page 40, my lord, sorry. Annexure P13.
Page 30.
No, my lord, it will be page 35, my lord.
Page 35 is dated 2013. When did you retire?
13, my lord. It is a 2013 representation. I have retired in 31st October 2022.
31st of October 22 is the date of retirement.
My lord.
And when was it, since when has it been approved?
My lord, kindly comes to page 34.
34.
My 33. Letter of appointment issued on 16th of December 2009. Although your lordship will find the initial letter of appointment at page 26.
33 is from 2009 and 26 is from?
8th of, it is issued on 4th of December 2001, but I have joined from 8th of January 2001. Appointed at 4th of
Tell
December.
me one thing, in 2009 you got to know that you have been approved from 2009 onwards.
My lord.
And you say you ought to have been from 2001.
2001.
And you are coming in 2026. What does it mean?
Not 27, but 2024, my lord. After.
Assuming 24, what were you doing for the entire period you remained in service from 2009 till 2022,
My lord,
the date of your return?
I also on the same understanding of your lordship, my lord, but let the representation be considered in accordance with law. That might have subserved the purpose of the petition. However, my lord, even after that, it is a matter of record that I have worked from 2001. There is no dispute. Your lordship will find the approval of panel from my lord.
There is a principle of waiver.
No, my lord, not waiver. My lord, I have during this service tenure, I have submitted the representation.
And not moved.
Not moved, my lord.
10 years you've not moved. What does it mean?
My lord, develop, my lord, that, my lord, kind. Let that be, let it consideration.
Ajay, please come. The petitioner claims to be serving in a school from the year 2001. Stop. His service was, however, approved from the year 2009 and he retired from service on 31st of October 2022. Stop. While the petitioner was in service, he applied before the authority What is page 35? You say that you have not been paid your salary. You have never applied for counting your past service.
No, it's a Group D staff, my lord.
Maybe.
Group D staff, man, not very well.
কি বললাম appointed যেখানে বললাম না appointed claims to be appointed in the year 2001 as Group D staff in a school. ঠিক আছে? In the year 2013, mentioning that he was not paid his salary in the proper scale from the date of his appointment till the date of approval of his service. Stop. There was no response from the end of the authority. Stop. In September 2024, the petitioner applied afresh. Where is the proof of service of page 36? Nothing. That means it was never filed.
No, like,
Where is the proof of service?
Service
কি বললাম? The petitioner claims to have applied. Where is the proof of service? Nothing. Prepared only for this writ petition.
Well, let me come back with the instruction in that event, my lord. I believe that it has been served. I believe.
Assuming it has been served without the proper proof, can the court take into consideration?
My lord, I shall file in that event supplementary exhibit.
কি বললাম?
Or my lord, kindly.
Filed a representation before the authority. দেখলাম? Petitioner claims to have filed a representation before the authority, seeking benefit of his past service from the year 2001 till the date of his approval of appointment in the year 2009. Stop. The same is alleged to be kept pending. Stop. Paragraph. Prayer has been made to direct the respondent authorities to consider the representation filed by the petitioner, claiming benefit of his past service. Stop. You are there? No. Nobody is there. None appears on behalf of the state respondents. Stop. On a perusal of the documents annexed to the writ petition, it appears that the petitioner remained in service from 2009 till his retirement in October 2022. Stop. During the entire tenure, he never approached the authority for granting benefit to his past service. Stop. After retirement, the petitioner claims to have filed a representation in September 2024 seeking financial benefits of his past service. Stop. The said representation also does not bear any proof of service upon the respondents. Stop. Next. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to serve a copy of the subject representation dated 3rd September 2024 annexed as P14 to the writ petition upon the District Inspector of Schools, Secondary Education, Paschim Mednipur. Stop. If the said representation is served upon the authority, comma, the same shall be considered by the aforesaid respondent in accordance with law. Stop. Now, the fate of the representation shall be made known to the petitioner. Shall be considered in accordance with law within a period of 12 weeks from the date of submission of the same. Stop. The fate of the representation shall be made known immediately thereafter. Stop. It is made clear that this court has not entered into the merits of the claim of the petitioner, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the petitioner's claim. Disposed.
Extremely grateful. Great.
May I please, your lordship? I am for the petitioner lordship with regard to the petitioner lordship is in service. This is prepared for granting high scale of pay for his obtaining the PhD degree. But in spite of repeated representations, ultimately in the previous school, when before obtaining the PhD degree, Lord, he had to transfer to another school after obtaining the PhD degree. Representations are made in kindly see page number. It is rejected. That is at page number 15. Oh, sorry, page number 26. 26. 28. Page number 20. I'm sorry, page number 28. Thereafter, repeated representations are and recommendations are made by the school authority.
Page number 28 is the rejection.
Yes, my lord.
With reference to the subject.
Cannot be considered. Third line.
The prayer for 2 additional increment for PhD cannot be considered in terms of the school education department memo number pointed to regional. All right, yes, then.
But under Roper 90, he is entitled. Lord, thereafter, after new school also authority repeatedly made recommendations. Page number.
Did you challenge this? Page 26, 28, 2007?
Not challenged.
Then what is the next page?
Left unchallenged.
What is the next page? 8350? You are Deepak Kumar Khandar.
Deepak Kumar Khandar.
What is this 8350 2010? Page 29?
Page 29, my lord. That is the Assistant Secretary. This is with regard to, my lord, to next school. That
next
is
school.
My lord, by virtue of order of the small court, you have
This remains unchallenged.
Unchallenged, left.
Then what is to be done now?
Thereafter, repeated prayers are also made, and kindly see the notice for demanding justice, wherein it is stated, page number 30.
Your demand justice will not serve the purpose till the impugned.
That can be considered. That is, it is stated, repeated in details that by virtue of Ropa 90, he is entitled. That's why, Lord.
What is his submission?
My instruction is, my lord, that he has obtained PhD degree in 1st June 2006, my lord.
2006.
Now there is a notification on dated 2012. So there a cutoff date is mentioned, my lord, that the benefit in terms of Rule 12.5 of the Geo Daughter under ROPA 98 is extended up to 18th August 2005 as a cutoff date. That is till the before publication of the.
But this cutoff date was taken into consideration by the
Commission of School Commission.
Special bench of this court, and it has been possibly set aside. You please go through the judgments and you come back. There are several decisions in this matter. Utpal Kanti Karan is there, and other decisions are also there. Whether you can at all fix up a cut-off date or not. All right. So you come back. Please come. The petitioner seeks additional increment for obtaining PhD degree.
In mathematics.
Stop. The prayer of the petitioner stood rejected. Way back on 24th of January 2007. Stop. The petitioner renews his prayer for grant of additional increment. Stop. Learned advocate representing the state respondent submits upon instruction that as the petitioner obtained the degree after the cutoff date specified by the government, the benefit sought for by the petitioner cannot be allowed. Stop paragraph. To allow the parties to revert with further instruction in the matter, hearing of the writ petition stands adjourned till 7th August 2026. Stop. A written instruction from the District Inspector of Schools within bracket Secondary Education South 24 Parganas upon consideration of the law that has been laid down by this court shall be produced on the adjourned date. Take note.
Much obliged.
When did you file?
When we received the
Then how can you filed it on Friday and today it is affirmed? You have to affirm it first and then file. You cannot file and then affirm. Shondharani Jana has expired. Who is the legal heir of Shondharani?
The father, my lord. It's Sushi Bhushan Jana, assistant teacher of Ashadata Binod Vidyapit under Purbo Midnapur district, my lord.
No, Shondha has died, you say? Legal heir. She has died. Right.
He now died. He now died, my lord.
Now, who is the legal heir of Shondha?
All the legal heirs are substitution petition, my lord.
It has been submitted that the petitioner has expired during the pendency of the writ petition. Stop. An application seeking substitution. Not yet filed. Has you have? Oh, has been filed. Along with an application seeking condonation of delay in filing the said application. Stop. Let the applications appear in the list on Thursday, 6th of August. All right. Let a copy of the applications be served upon the learned advocate representing the state respondents. Yes, 17.
And for the petitioner, the matters relates to the interest of the area pension.
Interest on area pension. Who is the teacher?
My father was the teacher.
Would you stop, teacher? The PP was issued, my lord, and thereafter payment was made on.
PPO was issued in 2024.
24, my lord.
Yes.
The area salary was, area pension was paid on page 14, my lord.
Page 14.
1st April 2024.
1st April 2024.
7,43,809 without my lord interest. I paid for interest.
What is page 15?
Page 15.
Contempt?
A similar matter, interest
Oh,
of paid
similar matter.
9% paid interest for the area pension.
9% interest was, this order was passed long back.
Long back. 2021 in the contempt application.
Yes. Interest on account of your gratuity,
No, my lord, area pension.
arrear pension. You are the wife, widow.
I am the daughter of the pensioner as well as family pensioner.
You are mixing up everything.
Pensioner. Daughter of the pensioner.
You are the daughter of the pensioner. Where is the widow?
Widow already deceased, madam. Father and mother also deceased.
And who are the other heirs?
Father has no only single heirs. I am the daughter. They indicate in the PPO, my lord. Kindly see page. Page, my lord, page 12.
Amita Sarkar. Acha. Daughter of the deceased teacher.
Left hand side.
Hmm.
Serial number 8.
Burial.
Amita Sarkar.
Interest on arrear pension. And disposed.
I appear for the petition with Mr. Sarkar. It is a case of suspension in respect of a criminal case, my lord, under section 498A 325 506, etc. My lord, I am an assistant teacher, approved assistant teacher of a government aided recognized school. My lord, I was detained for 2020 detention of the criminal case. Then, my lord, a retrospective order of suspension order was issued, which is, my lord, at page 64 and 65. 64 and 65.
What is your prayer now?
With, recalling of the suspension order.
Any,
because, my lord,
any disciplinary proceeding initiated?
cannot be because the allegation of 498A, even no allegation against me of 498A cannot be. The lady who, my lord, lodged the complaint.
No, that the court is not looking into.
No,
but
no,
then
no,
fact remains, no disciplinary proceeding has been initiated against you. And after the suspension, were you permitted to join? No.
I was
On releasing on bail?
Not yet I have been permitted to join.
Page 65.
Order of suspension is.
I am for the school authority,
All
page
right.
65.
I have made a representation. It was not considered.
65.
Arrested on 26 March 2020.
Page 65.
Page 65.
No.
Suspension order.
Suspension order. Suspension order.
Huh. With effect from 9th of April 2020.
The first day of detention
issued on 2024 because he is suppressed there. He was arrested, entire arrest, his arrest, totally suppressed. He joined, after taking leave. School also never,
knew about his arrest.
Never intimated.
He was arrested
after enlarged out bail, he
casually joined, as if only.
I being the school headmaster, my lord, intimate to the board now as per the new rules. Headmaster, my lord, the board has suspended with retrospective from the date of
COVID period. I could not join even. COVID period. 2020.
No. That is not there.
April 2020.
Detention, kindly see, my lord.
Whatever. Now there is a request before the school. Let the school take a decision.
My lord, what I want. It is my lord, law is judgment that my.
Let the school take a decision fast. You never know.
Order was no. They had not.
Suspension order was issued by the board.
After taking consideration of the judgment of this honorable court.
Board will consider.
May I, my lord,
Judgment.
As per the new rules, my lord, the
judgments
of the rule.
Two judgments.
Board is the
as per rule 6 of the board is the competent authority.
Kindly see, my lord.
For suspension, withdrawal of suspension.
Please come.
There is no involvement with the, my lord,
The
official duty as a teacher.
petitioner is an assistant teacher of a government aided school. Stop. He was arrested in connection with a criminal case in the year 2020. Stop. On being released on bail, comma, the petitioner joined the school. Stop. The petitioner, however, did not intimate the school the reason for his absence for a period of how many days he was in custody?
28 days.
For a period of 28 days when he was in custody. Stop. Later on, after the school got to know about the petitioner's arrest, comma,
No complaint was
intimation.
made by his wife.
Oh, his arrest, comma, the school intimated the same to the West Bengal Board of Secondary Education. Stop. By an order of suspension dated 9th September 2024, the President, comma, ad hoc committee of the West Bengal Board of Secondary Education issued an order of suspension of the petitioner with retrospective effect. Stop. The same is impugned in the instant writ petition. Stop. Paragraph. Submission of the petitioner is that as the as the criminal case is not related to his service, comma, accordingly, the order of suspension ought to be revoked immediately. Stop. In support of such submission, learned advocate for the petitioner relies on the judgment delivered by this court on 11th August 2006 in the matter of Molloy Kumar Laha versus Vishwabharati and others.
Paragraph 10 and 11.
Stop. Paragraph
10 and 11.
Learned advocate representing the school authority submits upon instruction that the petitioner suppressed the fact of arrest and being enlarged on bail. Stop. He took casual leave and joined duty. Stop. The school was not aware of his arrest. Stop. Paragraph.
Then and 11.
Upon hearing the submissions made on behalf of both the parties and on perusal of the documents placed before this court, it appears that the petitioner has already applied before the board for revocation of the order of suspension. Stop. The said application is pending consideration till date. Stop. Next. Accordingly, comma, without entering into the merit of the prayer of the petitioner, comma, the instant writ petition stands disposed of by directing the board to take a decision on the petitioner's prayer strictly in accordance with law and in line with the decision laid down in the matter of Molloy Kumar Laha within brackets Supra, after giving reasonable opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 12 weeks from the date of communication of this order. The fate of the petitioner's application seeking revocation of suspension shall be made known to the petitioner immediately thereafter. The school, did the school initiate any disciplinary proceeding? No.
But he did not, my lord, he did not apply before the board for revocation of suspension.
He did not?
No, my lord,
the school.
The school did not pass any order of তাহলে ওখানে একটা বললাম না যে he applied before the board, সেটা নেই, ওটা আপনি লিখুন The petitioner is yet to apply before the board seeking revocation of suspension. তাহলে লিভ দিন, directed to consider বললাম তো, consider হবে না। In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply before the board seeking revocation, along with all documents in support of his prayer. In the event such a representation is made, the same shall be considered by the board in accordance with law and in line of বলে যেটা বললাম। ঠিক আছে? Take back your
judgment is of my lord justice Bhaskar lordship and was parent judgment.
Take this back.
My lord, before one indulgence.
এক মিনিট, ওই যে ডিসিশনটা বললাম তার সাইটেশনটা কি বললাম? Advocate for the petitioner is directed to forward a copy of the judgment delivered by this court in the matter of oita supra. Give the reporting once. দেখি তো ওটা রিপোর্টিংটা দিন।
Another my lord judgment of my lord justice Bhaskar Bharaj.
Page 32.
এই রিপোর্টিংটা দিয়ে দেবেন তো। Reported in 2006 to CLJ. CLJ page হচ্ছে 456. CLJ within bracket cal 456. আরে অত দেখাতে হবে না। আচ্ছা একটা থাক, এটা থাক, ওটা বই লাগবে না,
ওটা ভাস্কর বসাই
টেকেন অন রেকর্ড।
কপি আছে, কপিটা দিতে
ঠিক আছে,
এই বইটা আছে
দরকার নেই। I have kept one.
একটাই হবে, ওতেই হবে।
আচ্ছা 19টা একটু ডাকুন।
Timeline my lord consideration within
12 weeks has been mentioned. 12 weeks has already been mentioned. 19.
I am for the petitioner, my lord. Interest on gratuity, my lord. Single PPO, my lord, died in harness. We do come before this court, my lord.
Who has come? Widow.
Widow, my lord.
Widow has come 2018. It was issued. Date of death January, and in December
21st January.
Oh, right. Why have you come now?
5 years, my lord, he has come.
Why have you come now? Delay dismissed.
Gratuity PPO issues on 24th December 2018, my lord. And my lord, gratuity received in 11th
Your
January.
petition is dismissed.
My lord, may I have your lord?
এখনো খুঁজে পাইনি।
My lord, one indulgence, my lordship, one indulgence, my lord.
এটা delay dismiss.
My lord, may I have your lordship?
Interest on gratuity. Give your appearance.
My lord, may I have your lordship? In the morning, your lordship allowed the upgradation. I have submitted the slips. My lord, thereafter, I heard, my lord, your lordship is wanting to give the urgency written. My lord, may I have your lordship to just write the urgency?
Will you be able to find out your sleep?
My lord, my sleep
more
is
than
in
100
paper. I hope I can. I will try, my lord.
Come tomorrow.
My lord, one indulgence, my lord. On item number 12, Mr. Sudeep Palit is appearing for the petition. My lord, got dismissed for default. He's suffering for fever. My lord, kindly keep it not today. That is as per his instruction. I am paying before.
Only not today.
Only not today because he.
Tomorrow he will be all right.
As per his instruction, I am addressing.
Yes, as per his instruction, he was awake till late in the morning, and that is the reason he could not attend court.
My lord, I don't know.
I can understand.
Whatever.
12 নম্বরটা not today করে দেবেন তো।
Great.
আচ্ছা আমি ফেরত আসি। Let the council come.
Oh,
Let us see.
আমাকে যা বলে